So you think that in a lot of ways, only larger companies are going to be able to take the risk of using this data with the ominous cloud of litigation like hovering over their heads, or
No, I mean, in every area, I mean, look, I think to a large extent, many of the large language models will primarily come from larger companies because of the cost to train them, to acquire the data, to train the models, maintain the models. But there's startups that are also getting significant funding to do it. So it's not that there'll only be big companies that are doing it. And I think the users are ubiquitous, from individual artists through companies. So, I think that there's going to be a lot of players in the ecosystem. My point on the big companies was that, if you're relying on an indemnity, you want to make sure that there's something behind it. And certainly a big company, typically will have more behind it. If it's a startup and it's well funded, there may be sufficient backing there as well. But you want to just take that into consideration.
do you think that, like, I know that Google recently updated its user agreements. How do you see, like, I mean, you're advising companies, right? What are you advising them to do to prevent litigation, I guess?
Yeah, so really the main thing is to adopt a policy, depending on the company's how they're using or want their users to use AI. The types of uses, it varies in some cases by even within business model, with business units within a company. There can be different policies depending on like how important the output is, and various other things. But the other thing, to your point, Julia, is that I think it's really critical not only to establish a policy, it's really critical to update it. I'm recommending the clients do it quarterly, because these tools, with each new model, and sometimes even in between, the terms of service change. And so, you need to stay up to date on what's going on. And, one of the things, and again, each company's policy varies depending on their use and risk profile, et cetera. But, one of the things I think that's important is to, take a look at what the terms of service say. And it can be, important from understanding like what the company does or what tools they offer to help mitigate infringement or things like that, and any indemnities that may come along with it. And I said that can change from one version to the next.
Go ahead.
Oh, just like branching off of that in terms of like, I guess, corporate advice. I was also interested, how are you advising corporations on how to prevent them from using biased data? Like how, because that's, I guess there's two factors: the risk of litigation because of, using data that they don't actually have permission to use. And then the second is they're using data to train their AI to create a sort of like biased AI model. So like, I guess.
Yes. Yeah, so it is not easy, but a lot of it comes from testing. So, if you're going to train a model, you want to test it to make sure there's no bias, and there's different, kind of protocols that are being developed to do that. The FTC is kind of issuing some guidance, pretty high level guidance, but that's one thing. That's kind of more of a complicated technical answer, and it kind of varies depending on where the data is coming from and what the model's being used for, and a bunch of other factors. But the short answer is test the models before you deploy them, and that's one. And the second thing is that it's important to understand is that there are certain states that are actually passing laws that have already passed, like New York, for example. Like if you want to use AI in connection with screening resumes or hiring decisions, there's a specific set of things you must do before part of it's disclosure, part of it's ensuring lack of bias and other things in some of these laws. So, and I think you see more of those. So, part of it's going to be like, depending on where you're using it or what employees are affected, is to understand what the law is and do whatever's required by that state law. The FTC also has, general information about bias, and they think that can be, that they have jurisdiction over tools that are biased under deceptive advertising and some other things within their purview. So it's kind of a complicated thing, but a lot of it comes down to adhering to the protocols and testing and doing the best you can to avoid that the data itself doesn't have bias in it, and that you don't train things in a way that the training or the algorithms are biased.
Thank you.
I think just to go back to the ongoing litigation surrounding generative AI, I think I've had a chance to read through some of the JLV Alphabet complaint. And I think my reaction, and I imagine a lot of other people's reaction when they learn about the sheer scale of the data that Google is accused of vacuuming up, and this data includes sensitive and highly personal data, as you already mentioned. It can include copyrighted or at least copyrightable materials. And I think the question, as I read it, that complaint really poses, in addition to all the formal causes of action, is how in the world can Google and other companies be allowed to get away with this? And so this is a very long-winded question, but I'm wondering, out of all of these different claims, there's several in the JLV Google case. There's negligence, invasion of privacy, some consumer data protection-based claim, as well as copyright claims. Is there one or a couple of legal strategies that might be more effective than others in containing this vacuuming up of so much data?
Yeah, so I'm going to refrain from commenting specifically on what Google is or isn't doing. And, a lot of people have read the complaint and some people have shared similar views as yours. I think to keep it on a legal analysis is, there's a lot of different buckets of data, and certainly the quantity is significant, but all of these large language models are trained on significant amounts of data. And it still comes back to, I don't mean to be repetitive, but it comes back to what I said in the beginning. You have to look for the different types of data. Do they have a right to use it? I mean, it's the same, there's going to be different analysis, because some of the data they acquired from users, some they're getting from, web scraping and other like services or other, third-party stuff. Some is copyright protected, some is not. And I think in my view, again, putting Google aside specifically, I think courts are going to look at this and say, just because there's a lot of data doesn't mean you're necessarily liable, right? I mean, the visceral reaction is there's got to be something there, right? That's what a lot of people I've heard have said. I'm like, but if you look at the lawsuits that have been filed and the motions to dismiss, the courts are like, yeah, but show me, like in some of these cases, like, people have filed copyright infringement, they don't even have a registration, right? So those got bounced pretty easily, right? But when you get to the more serious, claims, I think it still comes down to showing specific data that was used to train without permission. Was that infringement, or is there fair use, and or is it actually used in the output, which is another part of the question, right? And so, when you think about, and again, this is a broad analogy, but just because you train on certain data, it may be that there's infringement, but it's also possible when you think about the argument, that the counter argument a lot of people say is that a lot of artists look at a lot of artwork, right? And we as humans, we learn by seeing things. That's one of the goals of the patent system and the copyright system, is for people to publish their work so other people can see it, both for enjoyment, but also to advance the progress of science and the useful arts. And so it's very common for artists to take into account what they've seen. Now, there's a big difference. They're not making a copy, right? They're not making a copy, making like something electronic and a tool that derives art from that. But they're still using their brain and saying, when they see stuff, they're kind of then putting their own spin on it. And theoretically, that's what these AI models are doing. They're abstracting information about the art, or at least what they're supposed to be doing, what they claim to be doing, and they generate, they have information that is used to create new images. And I don't know how it's going to come out. I think it's going to be fact specific. But I know that there are, for all the artists out there, they're deathly afraid that if this is not infringement, then it's going to put them out of business. And so I think that's a serious, societal concern that we need to think about, both whether under the existing law that this can be done, or if so, should we change the law to permit some form of compensation to artists or other. It'd be complicated to do that, but I think there's two big issues. What is the existing law, and should we change it? And if we're going to change it, they should probably do it pretty soon, because a lot of this material is being used to train the models. And so unless the law is retroactive, you have that other layer of, you know, when does the law come into effect, and you know, how much damage has already been done, if indeed there has been damage done.
Could you
So,
see
you know,
oh,
yeah.
I'm sorry.
One last thing. So, you know, it's kind of interesting because like with every new technology, when you think about digital music, and, you know, I mean, there was some stuff like Napster, which was, you know, clearly, you know, illegal. But, you know, there was a lot of resistance on the part of music companies to digital music. And, you know, technology keeps moving on. And I'm not taking a position one way or the other, but I think it's a really fascinating situation that we have here with AI, because, you know, you can see the great power and benefit. I mean, companies can now generate art, you know, much more cost effectively. You have like model agencies that are pure, like no humans, right? It's all AI generated models, right? So that's going to, you know, except for like runway models and stuff, you could significantly impact entire industries. And I think one of the big philosophical things is that good or bad? And, you know, when you think back, the last time we had this type of displacement was really the Industrial Revolution. People went from farms living out on farmlands to moving into the cities and working in factories. And while I'm sure it was painful and a big transition, you know, as it was happening, right? If we look at how society benefited, right, not the individuals who kind of lost out at that time, but how society benefited from it, there's arguments there too. So, you know, I think there's pretty compelling arguments on both sides. And this is one of the things that makes it really challenging, I think, for legislators to figure out, you know, what should the policy be while the courts figure out what the existing law is.
There was something you said earlier, which I was thinking about, which is, I guess, that the bar that must be passed in litigation when it comes to proving copyright infringement is you have to prove that really, I guess, the copyrighted work was really used in the output. But with this black box, which is AI, like, do you think that that is an appropriate, I guess, rubric to judge copyright infringement?
Well, so I think, let me clarify what I said, and then I'll finish answer. So some of the plaintiffs are alleging that just the mere copying, right, that the mere training requires making a copy, and that in and of itself is illegal. Or not illegal, but it's copyright infringement. So that's one argument, right? The second argument is, even if training is per se is not, the question is like more like the ebooks case of what comes out on the other end, right? And so, you know, if there's an infringing copy, then that's another argument that's infringement, even if the training by itself wasn't. So it could be either or, but you know, I think that whatever test the courts adopt, right, there's going to have to be specific facts. They're going to have to be someone with a copyright that shows their work was used, and either the training itself, the way the training occurred. Again, the training is done differently in different models. So it may be, I don't think there's going to be a per se rule that training on copyrighted works is or is not infringement. It depends on, I think it'll depend on how you use it and in the training. So that's one question. And the second is on the output side. And so if you know, what one of the cases that are, you know, I think very illustrative of this point is in the Getty case, right? They got some images that actually have Getty watermark, right? You know, and you know, you can make different, and we'll see what happens in that case. But if you're actually copying elements of an image, like a watermark, right? If it could be just it was poorly trained, right? It could be, you know, that was part of how it was trained, and that needs to get fixed. But if you're training it and you're actually taking actual elements and you're making it into the output, I think it's probably more likely that they're going to be able to make a case for infringement. But if a work is just like wholly created and it doesn't, you know, it doesn't fit the definition of derivative work, at least in the US, and the test is different in other countries, I think it's going to be hard to show the output is an infringement.